Okay, so welcome guys once again to our discussion on law of movable property, land law. As you see in our series of videos that we've discussed, the defenses to actions in land. In the first one that you saw, we discussed the defense of adverse possession. If you've not watched it, I entreat you to also watch adverse possession. But for the benefit of those who may just be looking at this video for the very first time, we've said that if maybe someone goes into possession of a land, okay, and another person also claims an adverse interest to that particular land. That is what I mean. So A, for example, goes into possession of a land, or he purchases some land, another person now surfaces, B surfaces and says that, hey, A, this land that you are claiming that you've bought, the land belongs to me, okay? Or this land that you, A, you are in occupation of, this land belongs to me. So now we are saying that what is going to be the defense of A against that particular action? So let's say that the person B now decides to take the matter up to court. He brings an action. That's what we say. He maintains an action for declaration of title to the land against A. Sometimes he goes ahead to seek an injunction and all that. What is going to be the possible defenses? So we've explained one of them to mean the defense of adverse possession. In this video, we'll focus on the other kind of defense that will avail to a person who is trying to fight off an action in land matters, or an action in land where let's say the plaintiff is seeking to ask the court to declare title in his favor. Meanwhile, I am in possession of the land. What is going to be the defense? Now, we are saying that there is the defense of what we call Bonafide purchaser for value without notice. As you have seen, Bonafide purchaser for value without notice. What is actually the ambit or the scope of this kind of defense that we are talking about? Bonafide purchaser for value without notice. Now see, when we say bona fides, I mean, I'm sure if you remember some of your Latin, bona fides means that in good faith, okay? So a bona fides purchaser is someone who has bought it in good faith, in all honesty, in all sincerity. That is what we mean. For value, I mean, he put in some kind of consideration. It was not just gifted to him. He bought it for value. Bona fide purchaser. But now he says that for value without notice. What do we mean? Now watch. This kind of defense is an equitable defense, or it's a defense in equity. You remember, we said that equity is kind of the moral construct of the law. Sometimes if we are choosing to just apply the law strictly as it goes by the books, the person will not be successful. So for example, you're on the land and someone has a lease document, or someone has some other rival document, and the person now says that the land belongs to me. So you've also bought the land. We are saying that what is bona fide purchaser in that? It is equity. It is an equitable remedy or an equitable defense. An equitable defense means that if we were going by the strict construct of the law, the written down law, you would not have had any means of sustaining a defense against it. But we now try and look at the morality of the defense, the morality of the situation in which the person has found himself in. And that seeks to avail to him a defense. So we are saying that the bona fide purchaser for value without notice is a defense in equity. It is a defense that we look at the morality of the situation and we try to defend the person, or the person tries to use that as a defense. That is what we mean by that. Now, the requirement for bona fide purchaser for value without notice. Notice of what? What do you mean by notice? Let me just complete that section. When we say bona fide purchaser for value without notice, it means without notice of any encumbrances, without notice of any adverse claims of possession. That is what we mean. So if someone goes to purchase a land, okay, and he bought the land without knowing that there was a third person who had an interest in the land, there was someone else who was claiming a superior title to the land. He didn't know. We are saying that he bought it for value without notice that there was an encumbrance, without notice that there was someone else who was asserting a rival claim. The law is that we will have to defend the person so that he holds on to the new title or interest in the land that he has acquired. But before that will happen, what should be the requirements? He ought to satisfy some legal requirements. So essentially, guys, at this point, let me summarize. Bona fide purchaser for value without notice, I've explained. It is an equitable defense. It is a defense in equity. That is where we try to now set aside the written requirements of the law and try to protect the person who has bought the land. And we do that on the basis that he has bought it for value without notice that there is an encumbrance, without notice that there is a third person or another person who has a rival claim to that. All right? So at this juncture, also for the students, if you are answering a question on land law, okay, immovable property, and someone is bringing an action against another person for declaration of title to land or recovery of possession, asking the court to take away the land that the second person is in possession of, and you want to respond to the defense that can avail him. One of the defenses, apart from adverse possession, which can be in one breath, will also be the defense of Bonafide, purchaser for value without notice. But you see, we've mentioned notice. All right, so what exactly do we mean by that? Okay, now here's the thing. When we say for value without notice means that, remember, without notice of an encumbrance, without notice of the adverse possession, or without notice of adverse claims of a third party, that notice could have been presented to him in two ways. He could have had, one, an actual notice, or two, a constructive notice. You understand that? So when we say without notice, which means that he didn't have actual notice, and he couldn't have also had constructive notice. All right. So the summary of it is that the person ought to have exercised due diligence and care in the way he acquired that particular land or property. You understand that? So if the requirements of due diligence is satisfied by this person, who has now gone onto a land that a third person is raising in claim, if he did due diligence, and yet the due diligence efforts that he manifested showed that he was right in acquiring the property, then the law will protect him. So we are saying that that due diligence should mean that he didn't have actual notice, and he also didn't have constructive notice. So we know what actual notice is. Actual notice will simply just mean that there were not any grounds, or there were not things that he could have visually seen or observed that could have told him that this thing belonged to somebody. You get it? That is what we mean by actual notice. Or there was nothing that he could have perceived with his real senses in real time to have given him any notice that that was it. Then there's another aspect of what we call constructive notice. Now, for this issue of constructive notice, I want to refer to a very old common law case, and that case is Espin versus Pemberton. Okay, so in Espin versus Pemberton, Lord Chelmsford gave us a bit of statement, and that statement helps us to get the cracks of what we mean by constructive notice. Let's see what the court said in Espin versus Pemberton by Lord Chelmsford. Espin versus Pemberton, per Lord Chelmsford, Lord Chancellor. Constructive notice, properly so called, is the knowledge which the courts impute to a person upon a presumption so strong of the existence of knowledge that it cannot be allowed to be rebutted, either from his knowing something which ought to have put him upon further enquiry, or from his willfully abstaining from enquiry to avoid notice. Guys, you saw what Lord Chelmsford said in that remarkable case of Espin versus Pemberton. When we talk about constructive notice, the position of the law is this. If there is a knowledge that anyone could, upon due diligence, have acquired, but he refused to allow himself to acquire that particular knowledge, we still say that he has constructive knowledge of the particular matter. Or he abstains from enquiry just to avoid notice, we will still say that he has constructive notice. So let me just put the land law aside and let's just go. Let's say that a man is living with his wife in a house. Now, somebody comes looking for the man. When he came, the man was not there. Then he told the wife that, oh, I'm looking for your husband. Where is he? The wife said, oh, my husband has gone out. Okay. So when he comes, tell him that I'm here. Now, the man later says that his wife never told him. Now, do you know that if there is evidence that he was living with his wife, and for example, the person came to the house repeatedly and told the wife, it will be very difficult for the man to now say that I didn't know because my wife didn't tell me. Don't you think so? It will be very difficult. Why? Because the stronger presumption is that if you are living with your wife in the absence of any difficulty, we expect that if someone comes and asks of you, your wife should be able to tell you that you had a visitor, true or false. So if I don't come, if the person comes and doesn't meet you personally, and he tells your wife, leave the message with your wife, it could be constructively said that you had noticed that someone came to look for you. So what we are saying, because ordinarily, if you were speaking with your wife, you would have also asked her, Ama, Ekuya, Ajua, did anyone come looking for me? Or, the course of the discussion. Guys, you get the point. So Lord Pemberton is trying to say, Lord Chelmsford is saying that when we say constructive notice, the court will always impute a knowledge to a person And that knowledge is based on a presumption that he had some means of understanding the situation that was going on, or he refused to reasonably avail himself to notice because he didn't want to do that at all. So if that happens, we say that constructive notice will kick in. Now, as we go and as we discuss the effect of these on the defense of Bonafide purchaser for value without notice, I will explain a lot of practical examples to help you to understand. So, guys, the point at this juncture is that when we say Bonafide purchaser for value without notice, we are saying that a person could resist an action, okay, for the declaration of title to land, or could mount a defense on the equitable grounds of Bonafide purchaser for value without notice if he has done due diligence. And that due diligence will mean that, 2, the combined effect of an actual notice or a constructive notice did not permit him to know that there was a third party or another person who was exerting the rival claim to the land on which he had bought. It is only upon that grounds that a doctrine of Bonafide purchaser for value without notice will avail to him. All right? Hello, lovely people. I'm sure you're enjoying our videos. As you've realized, our videos are in 2 parts. We've got the course-based ones that discusses the various sections of the law, and we've also got the everyday law. The course-based are designed for academic study and in-depth understanding of the law. But if you are interested in knowing about the law as it will appear or it will be useful for an everyday man, please always try and keep a focus on the everyday law content. It is done in vernacular and in simple and easy ways said that the man on the street will be able to appreciate the law in his daily life. If you stand in need of any academic support for any of your law courses, please do not hesitate to reach the number below, either via call or by WhatsApp. Stay tuned for more of our videos on Supreme Law Publications. Okay, you got that? Fine. So now you see, the courts of Ghana has therefore put this particular position of Bonafide purchaser for value without notice in its appropriate context. In a very remarkable case, which was entitled Osmanu versus Osmanu, you may have heard of it, Osmanu versus Osmanu. There was, in summary, a man who was living with his wife in a house. Now, the man went behind his wife and sold the property to another person. So this person bought the property and paid for it and all that. And while attempted to go and what? Take over the property. But you see, when he was going to buy the property and he visited the man in the house, the man's wife was there. The man's wife was in the house. When this third person had gone to do an inspection, and he saw that the man was living in the house with his wife. So eventually he said that he had bought the house. And the wife said no, she's not going to agree to the fact that the man said he has sold the house. So this matter went to court. The question is, this third person who went for an inspection and he saw that the Osman who was living in the house with his wife, okay, and still went ahead to buy it. The question is, do you think that defense of Bonafide purchaser for value without notice will avail to him? Are you sure he didn't have notice that there was an encumbrance? Because someone is living in the house with his wife. So how do you make a purchase of a house when the woman is there and you went there, you didn't even talk to the woman? Guys, you get it. All right, but so the point is this. If the man had done his work well, he would have known, or it should have been obvious to him that there was a family interest in the land. When I say family interest, which means there was a spousal interest in the land because the person is living there with his wife. So at least your investigation should be able to lead that to you. So the courts, in therefore reviewing Osmanu versus Osmanu, gave a very powerful explanation or a guide that helps us to understand this whole caboodle of what we mean by Bonafide purchaser for value without notice. And let's take the quotation that the court gave in Osmanu versus Osmanu. By court, any intending purchaser of property is put on his inquiry to make such investigations as to title as would enable him to rely on the plea of Bonafide purchaser for value without notice. If he failed to make such inquiries, he acted at his own peril if subsequent events disclosed that there was a valid challenge to the title he acquired. Spot on by the Lord Justices of the court. You saw it. So if a person wants to now rest on the defense of Bonafide purchaser for value without notice of an immovable property, land, a house, he ought to go ahead and do an investigation. If he doesn't do the investigation and something arises later, he has purchased the property at his own peril. So guys, the whole ambit of bona fide purchase of value without notice means that before it can avail to someone as a defense in equity, he ought to have displayed or shown on the available evidence on record that he had done due diligence. The due diligence meant that he had done investigation. All right, so now let's go ahead and let's see some of the pointers that would now culminate in what we mean by an investigation. The first of them is official searches. Official searches. Now, what do we mean by official searches? Official searches simply means that within the laws of Ghana, we have an agency that we call the Lands Commissions of Ghana. If you read the Constitution makes a provision for the Lands Commission to be responsible for how land administration is done in Ghana. You may even be surprised, or you may know that in the Constitution it says that where you even have a stool land, and that stool land has not been properly demarcated by the by the Lands Commission, that land should not even be sold. Yeah, it's there in the Constitution. So basically, who is going to do that demarcation and retain the copies of the layout or those particular plot demarcations? Obviously, it's Lands Commission. So bona fide purchaser for value without notice will avail to any person if first he can establish that he did official searches on the land. So did you go to Lands Commission to check the land? Going to Lands Commission will review, for example, in whose name that particular property is registered. Okay, so it's very important for that to be done. Now, in a case that the Supreme Court decided, Kusi and Kusi versus Bonsu, her ladyship, Georgina Wood, Chief Justice, as she then was, in dismissing an appeal in a majority decision, made this particular point very clear, that the position of the law, or what is the establishment, is that in Ghana, Lands Commission is the required body or the official body where all issues about land is handled. So if anyone has got any issue that he first needs to establish, at least, and that's what the court held in Kusi and Kusi versus Bonsu, an official search at Lands Commission will review the issue or review if there are any subsistent encumbrances on the particular land. All right? So the effect of the bona fide purchaser for value without notice would first arise in the fact that anyone who seeks to rely on that should be able to go to the Lands Commission and conduct an official search, obtain a search report on the land so that he knows what is there. Okay? All right. That is good. So now, after we now know what the official searches will mean, second is physical inspection. Physical inspection. Now, what is physical inspection? Remember, in the common law case that we mentioned in Espin versus Pemberton, where we looked at the famed quotation by Lord Chelmsford, it said that a person or the court could impute constructive notice if there is a presumption of a knowledge so strong that we cannot allow that knowledge to be rebutted. That is, if the person was of the means to have understood or perceived certain occurrences, we cannot, at the time of determination of the matter in court, say that, oh, he didn't know. So physical inspection of land is very key, and it goes in tandem with this quotation by Lord Chelmsford. So if someone wants to now go in or rely on the defense of bona fide purchaser for value without notice, he ought to also physically go and inspect the land or the movable property. Now, going to inspect that land, we'll review whether or not there is a third party there who is exercising a claim over that. All right? Okay, so now see, in a Supreme Court case that was recently decided in a very stellar judgment given by Her Lordship, Justice Williams Jones Maulum Doche, Justice of the Supreme Court at the time. And the case was Olivier Nim versus William Janzi. Now, what happened? There was a land, I think somewhere at Shalibuchi or Yarifa, something like that. And this man, Mr. Janzi, had now gone to purchase the land. Now, when he went onto the land, there was a wall that had been constructed over two sides of the land. So there was a wall here, there was a wall there, and someone has also erected a house. And he still went ahead, bought the land, and attempted to develop. That was where Olivier Nim now came out and brought title documents to show that, no, that land belongs to me. That land belongs to me. So you cannot come and assert claim. So the back and forth was going, it was there, back and forth, back, forth, back, forth, back, forth, back, forth. Then the matter eventually landed at the Supreme Court. Now, when the matter got to the Supreme Court, Justice Josdoche said in the powerful judgment that he wrote, and he said, and I repeat, just a standard of it, he said that war is not a natural feature of land. War is not a natural feature of land. What's the import of this phrase that was put in there by the learned justice of the Supreme Court? The point is this. Nobody goes onto a land and after a day, you just see that the war will just spring out of the land. It doesn't happen like magic or miracle. Definitely, someone had gone there to possess the land and had done the construction. The effect of the William Olivier Nim and William Jansi case, therefore, amongst other cases, is that when you go and conduct a physical inspection, Bonafide purchaser will mean that you need to be alert to the occurrences on the land, the evidence of possession on the land. This evidence will be a water tank. The evidence will be, for example, a wall. The evidence will, for example, be stone and all those kind of sand and all that. It should be able to put the person on actual notice that there's someone who is exercising a claim or a rival claim to what he is seeking to achieve. And if he does not take it upon himself to investigate who is in possession of that particular land, and he goes ahead and something happens, the defense of Bonafide purchaser for value without notice cannot avail to such an individual. All right? All right. So now, speaking of things on the land, there is also the situation of what we call economic trees. Now, in a remarkable judgment that was delivered by one of Ghana's most venerable justices, His Lordship Justice Ni Ama Olenu, in the case of Norquay Tete versus Mao, there was a situation somewhere in Abeka where someone had now gone to purchase some land, and he had gone ahead and he had sought to register the land and all that. But you see, when he went onto the land, there was a mango tree. Okay, it was a mango tree. And it was clear that that mango tree was producing produce, mango fruits, that someone was plucking from that mango fruits. Okay, there was also evidence available on the record that if you observe where that mango tree was, it looked as if the base of the tree was always being swept and kept clean. So when the matter came for determination at the court, Justice Olenu in his judgment, excellent judgment, said that mango, it's part of an economic tree. It doesn't just grow in the wild. And for the fact that the person went there and he saw that there were mango trees on the land, and in addition to that, there was a conscious effort of people sweeping or keeping clean the base of the mango tree, means that there was somebody who was using that space. So if you, the purchaser, went there, you ought to have known, either by actual notice or constructively, that there was a rival person who was asserting the claim there. So the fact that he didn't do that, which means that he can now not mount a defense, not at least in the defense of Bonafide purchaser for value without notice, because he ought to have known, he ought to have been on notice that there was a third person who was asserting the claim that was different from his. So guys, the point is that the presence of economic trees, mango, pear, orange, trees and plants that do not just grow in the wild, they are evidence of possession. And anyone who seeks to defend an action in land on the basis of Bonafide purchaser for value without notice ought to have investigated that he was sure that there was nobody there. Okay? All right. Now let's go to the third one. The third effect of the rule or the defense of Bonafide purchaser for value without notice is that also upon the physical inspection, constructive notice will also mean that the person needs to be put on inquiry by speaking to the neighbors on the land, the neighbors of the adjoining premises. The person needs to learn about what is going on there. Now, in a case that was decided by the Court of Appeal in Kumasi, stellar judgment written by Justice Mariama, who is now Justice of the Supreme Court. The case was Kodjoa Samoa versus Angela Fritz. The house, this matter concerned the house somewhere around Pankrono in Kumasi. Now, these persons had gone there to want to go and purchase this building somewhere around Pankrono. Now, when they went there, they met Kodjoa Samoa, and Kodjoa Samoa was the one who was seen always coming into the house and developing it and all that. He entered into terms of agreement for a transaction to transfer the interest in that building to them. Now, the neighbors who spotted that these particular individuals were interested in purchasing the land, okay, in somehow by divine providence or something, engaged in a conversation with them and told them that, this building, we know it belongs to a certain woman who lives in Germany. She's the one that we know the house belongs to. But it is this man that we know who takes care of it, but we know the owner lives in Germany. Now, the neighbors told the purchasers that. Okay. Kodjoa Samoa even showed them documents, and in the documents, they saw the name of Angela Fritz there. All right. But they still went ahead to purchase the house. Then eventually, Angela Fritz came down from Germany And guys, you can guess what happened. It was bomb. So she interfered with the transaction, caused an eviction of Kojo Asamoah, and the matter went to court. So eventually, the Court of Appeal, as you know, had to now decide on the obvious. The question was, these persons who had acquired the property, do you think that the defense of Bonafide purchaser for value without notice would avail to them? Because they ought to have been put on notice constructively. When the person told you that the house that we know, it belongs to a woman in Germany, they should have investigated who this German woman was. And that was the position of the Court of Appeal. So since they refused, neglected, and failed to proceed with their investigations, the defense of Bonafide purchaser for value without notice did not avail to them, because they ought to have known that that particular property that they wanted was incumbent, or it belonged to another person. So guys, that is the point. Physical inspection will tell you acts of the neighbors, all right, and also official searches in there. So in summary, what do we mean, or what have we now discussed about the defense of Bonafide purchaser for value without notice? We are saying that if someone brings an action for declaration of title in land, and there's someone else in possession of the property, or there's another person who is claiming or seeking to resist that particular action, a lot of defenses could avail to him. The defense that we have focused on here is the defense of Bonafide purchaser for value without notice. And we are saying that it is a defense in equity. It is a defense that the person can only mount if he has been able to show conclusively to the courts that he has conducted due diligence. And this due diligence will mean that what he noticed constructively did not, by any stretch of imagination, indicate that there was a third person or another rival party who was asserting a claim to that. That will mean that he did physical inspection. That will mean that he asked of the neighbors. That will mean that he did official searches at the Lands Commission, and the title and the root of the grantor he properly investigated. If he is able to do that, then the defense of Bonafide purchaser for value without notice would always act as a shield for him, and he can maintain his interest in the land. So students, that is it. If you are analyzing any question on the law of movable property and someone is seeking to mount a defense in Bonafide purchaser for value, this is how you proceed to do your discussions, analyze it, apply it to the fact, then you hit it. Hope you're cool. All right. So stay tuned as you watch more of our discussion on the defenses to actions in land.